But let's continue with this particular story. We're bringing in legal analyst Zola Majavu now just to tell us his thoughts. Mr. Majavu, thank you very much for speaking to us here on eNCA. Looking at the arguments that were put forward last week, Thursday, by both sides in this case, did you, for instance, as a lawyer, expect the interim judgment to go the way that it did this morning?
Good morning, Masejo, and good morning to your viewers. Firstly, I must give credit to my colleagues who I believe argued very well for their respective clients. But equally, I am not at all surprised with the judgment and the reasoning underpinning it. In fairness to the full court, I think that the judgment was well reasoned. It is on all fours with the applicable prescripts that govern how interdicts are granted. Putting aside emotions and what our particular individual views may be, I personally cannot fault the judgment. It did go as I anticipated. And as a matter of fact, on a very lighter note, I did commend my colleagues shortly after the matter was argued, and it could have gone either way. But I do think that the judges, in my respectful view, got it right.
So part B of this particular case is obviously something that we're still waiting to hear from the judge. That has to do with the summons. President Cyril Ramaphosa saying that the summons from President Jacob Zuma should actually be, declared unlawful and unconstitutional. As a lawyer, after today's judgment in particular, Mr. Majavu, would you, for instance, advise your client to drop Part B of this particular case and just continue with what the NPA said they could prosecute, which essentially was Advocate Billy Downer and journalist Karen Moore?
Well, I think it would be unfair of me to hazard a thought, because I'm not privy to what is it that animated the instructions to my colleagues on behalf of President Zuma. Law is a game. Anything can be argued, and it may well be that they may succeed substantively in Part B. But from my point of view, I would have thought that it was a bit premature to proceed with this summons in the manner in which it was done. I would have waited for the principal accused persons to be convicted, and thereafter, armed with that conviction, I would have then urged my clients to consider this type of prosecution. But the manner in which it was done, strategically, in my view, is a bit problematic. But again, I'm qualifying that because I am not privy to what might have informed that particular view. Part B is still a long way to go, but the good thing that the judges did was to make sure that they urged the parties to go before the JP so that truncated timelines should be determined. Otherwise, if that were not to be the case, this is one matter that could drag on indefinitely, and it would not be in either party's interest or in the interest of justice for this type of matter to be dragged on ad infinitum. So I think there was a delicate balancing act that the court did, in as much as they dismissed the respondent's defense and granted the order in favor of the president. It can hardly be argued that there would be any prejudice suffered by the former president by this matter being delayed. It is not as if the court agreed with the president that the summons must be quashed. It was not a matter before this particular court, and rightly the court said, go fight it out in the criminal court. If the criminal court takes the view that the summons is fatally defective, then that is what the criminal court would say. But there was nothing stopping the president from stopping in its tracks a process that he contends would be an unlawful infringement of his constitutionally guaranteed rights. And the judge did go so far as saying those rights are not triggered at the first postponement. It's not a main convenience, but it is substantive rights that are implicated, and quite correctly so. But it's still a long way to go. It may well be that the president, the current incumbent, may not succeed, in which case he'll have a case to answer, or if he does succeed, then that's the end of the matter, and then all appellate processes may then kick in.
Yeah. Mr. Majavu, you and the judges are in agreement when it comes to the point you made earlier about possibly, telling your client that let's go with the prosecution that we have been allowed to go ahead with, and then from there, depending on how things work out, we start adding other people. Let's talk about the particular certificate, the Nolle prosequi certificate from the National Prosecuting Authority. Judge Sutherland, of course, with the other two judges, found it problematic that the certificate named any person, which means it's open-ended, right? It means that anybody can then be attached to this particular certificate. It means that after this, President Jacob Zuma could decide that he's even adding Judge Sutherland and the other two judges in that full bench to say that they also were unfair on him legally, right? So what do you think about this particular certificate? Should it perhaps be something that is considered to be set aside because it says he can name anybody?
I think the NPA know fully well that it was a bit clumsy on their part. It may well have been a deliberate plan to draft a Nolle prosequi in the general terms that it did. It is unheard of. It is quite inelegant, and it does not assist in terms of the administration of justice. So it is open-ended. So I align myself fully with the judge's criticism of that particular type of drafting of such an important legal instrument. But obviously, judges are insulated. Former President Zuma may not add Judge Sutherland and her brothers with whom his brothers with whom he appeared. But yes, notionally it is open-ended, and nobody sought to challenge its efficacy. I would have expected if I were acting for the former president, I would not have accepted a certificate crafted along those terms. I would have perhaps engaged with them further and insisted on something that is a lot more tangible and more clear, because that is the genesis, that is the pivot on which any private prosecution would rotate around. So if it is problematic, it therefore means anything that flows as a consequence therefrom could be fruit of a poison tree, so to speak. So it is indeed problematic, and they could have done better. And I know there are quite capable DPPs who could have assisted in drafting a legally sound document. But be that as it may, it is a document on which the former president has mounted his private prosecution, and they will stand or fall by that, unfortunately.
Yeah, and I don't know, Zola Majavu, what you think in terms of the fact that at the end of the day, there is a criminal a criminal case against the former president that is supposed to be playing out in the Pietermaritzburg Magistrates High Court, which has brought us to where we are today, and that part of the legal process has now been halted because of everything that is happening now. Would you agree with some of the analysts, some of your colleagues who say that President Jacob Zuma's legal team currently is doing a very good job at, playing delaying tactics in this particular case?
As a legal smith myself, I wouldn't title it legal tactics. They are simply carrying out their client's instructions. Whether or not there is merit in that type of approach is debatable. I, for one, would have preferred to get on with the show so that the allegations against my clients are tested and move towards vindicating my client. Because at the end of the day, you seem to be delaying the inevitable. And by so saying, I'm not for a second suggesting that the former president is guilty or there's any merit in the allegations against him. The fact of the matter is there are allegations that must be proved, tested, and they can only be tested in a court of law, not a court of public opinion. But I do not fault my colleagues. They are doing what lawyers do. Lawyers are creation of clients' instructions, but we don't even know what advice they may have given, which may have been accepted or not accepted. So it would be unfair of me to suggest that they are leading him down the wrong pathway. But safe to say that lawyers are creatures of instructions, and we differ in terms of levels of tactics and strategies. Just as well as the current president went to the courts, there's nothing wrong if the former president uses every single available remedy that the law permits. Whether or not one would have advised accordingly is besides the point. As long as the legal framework allows and enables whatever is being done, then so be it. At the end of the day, it is for the presiding judge to draw the line in the sand and say, beyond this and no more, and let's get on with the show. And judges do that not out of whim or fancy. They do so guided by the applicable prescripts.